Can my boss force me to work different duties? Imagine this. You're hired as a cashier, but suddenly your boss tells you to start mopping floors and unloading deliveries. Or maybe you're a receptionist, and out of nowhere, management expects you to take on sales calls and inventory work. That raises the question many workers ask. Can my boss legally force me to work different duties than the ones I was hired for? The answer depends on a mix of federal law, state rules, contracts, and whether you're unionized. In the U.S., at-will employment gives employers wide flexibility. But there are still boundaries. Laws around pay, safety, discrimination, and job classification protect workers from unfair or unsafe changes. In this video, we'll break it down clearly. We'll cover how at-will employment works, what the FLSA says about duties and pay, how safety and discrimination laws apply when contracts or union agreements matter, and what workers can do if the change feels unfair. At-will employment and job duties. In most states, employment is at will. This means employers can assign new tasks, change duties, or even terminate employment at any time, as long as the reason isn't discriminatory or retaliatory. So technically, your boss can reassign duties outside your original role. But at will doesn't mean unlimited power. Employers must still comply with wage laws, safety rules, and anti-discrimination statutes. A cashier asked to mop floors may be legal. A cashier suddenly treated as a salaried manager without overtime pay is not. Example, a retail associate hired to stock shelves is told to run the register. That's legal. But if the employer refuses to pay for extra hours or expects the worker to perform hazardous tasks without training, that crosses the line. Wage and hour protections. Under the FLSA, the Fair Labor Standards Act, FLSA, governs minimum wage, overtime, and classification. Job duties are central to whether you're considered exempt or non-exempt. Exempt status. Certain salaried jobs, like executive or professional roles, are exempt from overtime. But giving someone an exempt title doesn't make it legal. Actual duties matter. Duty changes. If your boss changes your work so that you're essentially doing manual labor but still calls you exempt, you may be misclassified. Overtime and pay. No matter what duties you're assigned, if you're non-exempt and work more than 40 hours in a week, you must be paid time and a half. Example, a hotel clerk classified as exempt supervisor is asked to clean rooms 50 hours a week without overtime. That violates the FLSA, because cleaning isn't exempt work. Safety rules under OSHA. The Occupational Safety and Health Act, OSHA, requires employers to provide safe working conditions. If new duties involve hazards, employers must provide training, protective equipment, and compliance with standards. Example, a receptionist is asked to handle chemical cleaning agents. If training or protective gear isn't provided, that's an OSHA violation. Probationary or not, new duties cannot endanger your health without proper safeguards. Workers who refuse unsafe work are also protected from retaliation under OSHA, discrimination, and retaliation limits. Duty changes can sometimes mask discrimination or retaliation. Title VII bars employers from changing duties based on race, gender, religion, or national origin. A.D.A. requires accommodations for workers with disabilities. Forcing them into unsuitable roles can be unlawful. A.D.E.A. protects older workers from being reassigned to lesser or more physically demanding roles purely because of age. Retaliation laws protect workers who reported harassment, wage theft, or safety violations from punishment disguised as new duties. Example, a pregnant employee is moved from desk work to heavy lifting tasks. If the change isn't medically justified and instead penalizes her for being pregnant, it could violate federal law. Contracts and employee handbooks. If you signed an employment contract, your job duties may be outlined in writing. Employers cannot simply change them without consent if the contract guarantees specific tasks. Even without contracts, employee handbooks often outline duty expectations. While not always binding, courts may use them to judge fairness. Example, a contract promises employment as an accountant. If the employer reassigns you permanently to janitorial work, that could be a breach of contract. Union agreements and the NLRA. Unionized workers enjoy extra protections. Collective bargaining agreements often specify job classifications and duties. Employers cannot change them unilaterally. If duties change, unions can file grievances. The National Labor Relations Act, NLRA, protects workers who collectively protest unfair changes. Example, in a unionized plant, management reassigns machine operators to janitorial tasks. The union can demand bargaining, and the NLRB may rule against the employer. Impact on benefits and career path. Duty changes can affect more than day-to-day tasks. They may impact benefits, promotion tracks, and career development. Health and safety benefits. New duties may expose workers to risks not covered by initial training. Retirement and classification. Changing titles or duties can shift pay grades, affecting 401k contributions or pension eligibility. Future jobs. A sudden reassignment may harm your resume if it downplays your role. Example, an engineer reassigned to clerical work may later struggle to prove technical experience for future jobs. Real-world cases. Case 1. Retail workers labeled managers, but performing cashier duties, sued for unpaid overtime and won under the FLSA. Case 2. A woman reassigned to heavy lifting during pregnancy won a discrimination claim under Title VII. Case 3. Unionized employees reassigned to different duties without bargaining filed grievances, and the NLRB ruled in their favor. Case 4. A construction worker forced into unsafe demolition without training won an OSJ retaliation claim after refusing. These cases show that while employers have flexibility, there are legal boundaries, what workers can do. If your boss forces you into new duties, here are steps to protect yourself. 1. Clarify expectations. Ask whether the change is temporary or permanent. 2. Check pay and classification. Ensure overtime and minimum wage laws still apply. 3. Document changes. Keep notes, emails, and schedules. 4. Check contracts or handbooks. See if duties are defined. 5. Watch for discrimination. If reassignment seems targeted, it may be unlawful. 6. Seek help. Contact HR, your union, or legal aid. In cases of safety, file with OSHA. Example, a barista suddenly required to do maintenance discovers state law requires safety training. She documents the issue and files a complaint leading to corrective action. The bigger picture, employers in at-will states can reassign duties, but they cannot violate wage laws, safety rules, or anti-discrimination statutes. Contracts and unions add further limits. For workers, the key is distinguishing between legal flexibility and unlawful abuse. Changing duties may be legal if pay and safety remain intact. But if new duties reduce your rights, increase risks, or punish you for protected activity, the law may protect you. So, can your boss force you to work different duties? In many cases, yes, at-will employment gives employers broad discretion. But that power has limits. The FLSA ensures pay rules still apply. OSHA guarantees workplace safety. Title VII, The A.D.A. and the A.D.E.A. protect against discrimination. Contracts and union agreements can restrict arbitrary changes. The bottom line, your boss can change duties, but they cannot use that change to cut pay illegally, endanger you, or discriminate. If the shift feels unfair or unsafe, document everything and know your legal options. If this video clarified your rights, share it with coworkers. The more workers understand about duty changes, the more power they have to demand fairness in the workplace.